the House Judiciary Committee this Wednesday afternoon, January 14th, and we're going to now turn our attention to another bill, H541, related to interference with voters and election officials. We'll have a walkthrough and then have some witnesses as well. So over to you, Tim. Thanks for being here.
Well, thank you very much for having me, committee members. For the record, my name is Tim Devlin, Legislative Counsel. Before you indeed have draft 1.1 of H4, 541, to do with a proposal to impose criminal and civil penalties on any person who interferes with voters' rights to vote or election officials for the purpose of disrupting the preparation or operation of an election. So I figured I'd start off today by just kind of situating the committee as far as powers in current law, and then explore the particulars of this bill. That sounds good.
Yeah, that sounds great.
So I'm not sure exactly how often this committee gets into election law, but just as a starting place, the U.S. Constitution, through the Elections Clause found in Article 1, Section 4, Clause 1, gives primary authority over election administration to the states. Of course, the federal government is entitled to legislate areas having to do with federal elections and civil rights, and so we see kind of a blending of authorities here of who can regulate what. Current law, when it comes to elections and interfacing with the disruption of, interference of, intimidation of, we do have some limited laws on the Vermont statutes annotated. I can just give you some brief citations. We have a criminal threatening law, which is 13 VSA 1702, and there are essentially augmentations under subsections D and F for voters if it occurs at a polling place or if it occurs against a candidate or election officials. We also have an entire chapter under Title 17, which is 17 VSA Chapter 35, named the offenses against the purity of elections. In here we have numerous offenses having to do with really, for the most part, kind of inappropriate behavior by either the election officials themselves or the voters themselves. What you don't see there is really third parties trying to interfere with the right to vote. There is, to a certain extent, we have in 17 VSA 1972A, which is actually in Section 1. I'll get to that ending today. It does get into the interference with voters. However, there's a limitation on the proximity having to be a polling place, and it's really couched in terms of trying to influence or induce a voter to vote this way or that, versus something more broader, such as just interfering with the right to vote at all. We also have 17 VSA 2017, which is an undue influence statute. Again, that's really more about the inducing a voter to vote this way or that. So turning now to the particulars of the bill, essentially have three sections. The first is amending existing law, which will be kind of made redundant in essence by Section 2. Section 2 has that new language regarding interference we'll get into. And then the third grants explicitly enforcement and investigation powers to the, in the civil context of this, to the state's attorneys and the Attorney General's office. And that would apply to all of the offenses against the purity of elections. Right now, we have parallel language in the campaign finance chapter of Title 17, not really anywhere else. I'll return to that a little bit later. So, Section 1 will amend 17 VSA 1972, which was titled Showing Ballot and Interference with Voters. The subsection A is kind of cleaning up some gender language, but really maintains the essence of the law, which the first part before the semicolon is about showing ballots and how that is still prohibited to do. And for those curious, this has to do usually with the idea of bribery or buying ballots, or buying a vote, and showing the ballot is different, how you prove to the person trying to influence that person that they've actually gone through with it. So that's remaining on the book. Interference with voters, and we'll see this at the top of page 2. This language is being stricken with the exception of the fine, which is now only going to apply to the showing ballot language. And again, this has two qualities I point out. Again, it has to do with the inducing a voter to vote one way or another, and it's also limited kind of geographically to the polling place. Section 2 is where we get into the real meat behind the purpose of this program. And this will create a new section to be titled 17 VSA 1973 Interference with Voters and Election Officials. I should just know that it may look somewhat familiar to those really versed in election interference law. Some of this language is borrowed from 18 U.S. Code Section 594, also called Intimidation of Voters. So first, we have the kind of penalty section up fronted, and this matches 17 VSA 1702 in the criminal threatening statute. Right, that should be 13. That's what it matches. And so it reads, starting on line 8, a person shall be imprisoned not more than 2 years or fined not more than $2,000 or both if that person intimidates, threatens, coerces, or attempts to intimidate, threaten, coerce. Essentially, we have two categories. Number 1 has to do with the voters, and number 2 has to do with candidate officials, particularly language reading any other person for the purpose of interfering with the right of such person right of such other person to vote, or to vote as the voter may choose, or of causing the other person to vote for or not to vote for any candidate for public office in any election. So we retain that inducing language and then add to it, augmenting it to the idea of further protection for the interfering against the right of somebody to vote. 2 has to do with a candidate for public office, a public servant, an election official, or a public employee for the purpose of interfering with the preparation or operation of election. And here I'll note that this is broader than current law, not only because you may notice there's not necessarily a location aspect to this. It applies to broader rights overall. It keeps the inducement, and then also gets to the preparation of operations in general, rather than the undue influence law already on the books in 17, has to do with influencing a specific choice being made by somebody. So this was broader to all operations. So this would cover anything from destroying of a drop box for ballots, or something that's not necessarily limited to the proper, having to do with stopping somebody from voting remotely. Much broader category of conduct can fit into this language as stated here.
Yeah, so
Go ahead.
I just missed it. You said this was language that was already somewhere else, or it's similar to language somewhere else?
Based on federal statute, yes.
Federal statute.
Mhm.
So we are just putting it in state statute to clarify. So it's already law at the federal level.
It's already law at the federal level, but federal law will only apply to federal elections.
Great, thank you.
That federal law.
Thank you.
Okay, so moving on to section 3, and this is where we have the added authority for enforcement and civil investigation to be granted to the AG's office, as well as state's attorneys. And again, this will, because we're being positioned in subchapter 4 of chapter 35, it will apply to all offenses against the purity of elections. About 10 or so statutes that are already on the books. This language may look familiar to some who are following the synthetic media bill that was in the Senate. That was S23, actually, certainly passed between the House and back at the end of last year. And I believe this was an ask from the AG's office to have these powers that were provided for in the campaign finance chapter duplicated here. The nature of these public election interference-esque violations. And so if it's all right with the chair, I figure I just kind of go through and summarize them versus kind of read out verbatim of that.
That's all right.
So first we have 2041 enforcement, and this provides SAs and AGs essentially with the ability to injunctive relief provided. Next section 2042 has to do with the Civil Investigation Authority. A1 will provide them the power to examine records. 2 will provide the power to issue subpoenas and depositions. 3 is a notice provision that will accompany those requests for records. 4 has to do with the disclosure of records, really essentially saying that they're confidential unless needed to be disclosed as a result of investigation by the AGs or the SAs. Moving on to 6, and that these will not be applicable to criminal investigations. Going on to subdivision B. 1, here we have a compliance provision that will have to be complied with by anybody subject to it. We have penalty provisions in 2, and here we have, essentially for falsities or refusal to comply, fine not more than $5,000. C, subdivision C, 1, non-compliance and filing of 4 orders. C2 we have for, grants court's jurisdiction and gets into some contempt of court powers. And then finally, subdivision D, we have the rights for the investees, those being investigated. That is the right to seek relief in court, and then also provides priority for such cases in court.
I think you did say this already, but to make sure that it's clear, this is language that is elsewhere in statute. We just need to have it in with this new provision. Is that?
Yes, the way Title 17 is currently composed, chapter I believe it's 61 or 63. I had to look that up for wherever campaign finance regulation is. There's similar provisions in there, but they apply only to those campaign finance investigations of campaign finance and its violations. In this other chapter 35, it's silent to there. So I believe there was just wanting of clarity that they have its powers in those situations.
May I clarify?
Yeah.
So it's not removing it in the other section,
No.
it's just replicating it
Yes.
here. Okay.
Yeah.
For subsection, in the civil investigations, A6, the subsection shall not be applicable to any criminal investigation or prosecution brought under the laws of this or any other state, page 5, line 1. So you're doing the civil investigation, you depose somebody, you could not use that deposition as grounds for a criminal charge under the new voter interference crime that you could potentially charge them with.
Yeah, that's a great question, and I will admit that the interface between criminal and civil matters in this regard. I'm not too familiar with that. I'd be more than happy to check with somebody on the Judiciary team and I'll get back to you.
Yeah. Okay. I guess I would be pretty curious about that.
Sure.
I don't know if it's appropriate. It's more just a curiosity. I just get curious how legislation is all put together sometimes. Because I know sometimes when we have new statutes, it'll say something like, in this case, it might be, and enforcement and investigation shall proceed as directed in blah, 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 this other statute, what you're saying is in campaign finance. Right. So I feel like we see that sometimes. So why is,
Be a cross-reference.
yeah, so why is it just duplicated here rather than having a cross-reference?
Sure. Let's see. Memory serves. I think the language existing in the campaign finance chapter has just numerous references to campaign finance kind of woven in throughout. So a simple kind of like bootstrapping it via cross-reference would be just a little awkward.
Okay.
So we made a drafting decision. An alternative could be to put it somewhere else in a new chapter in Title 17 that applies to everything in the title or just certain chapters here or there.
I was just curious because I feel like,
Yeah.
why do you pick one or the other?
Sure, but just to say, if there's a want for that to change, we can accommodate that. So
So where is legislative council on having one place versus in the other places? I mean, I don't know how much of a policy decision that is versus just how we construct our statutes.
Yeah, I guess it would depend on how many chapters and it would be connected to it. Or, I mean, in drafting perspective, we would just have to strike everything, existing one, and then create a new one. I would say we're close to indifferent on how it's done, as long as it's legally sound and we make sure.
Right, and if people are used to using that provision in the campaign finance one, why take with the why mess with it? So, okay. Other questions, Tim? All right, appreciate it. Thank you for the walkthrough, and we'll start with Secretary of State Sarah Copeland-Hanses.
Tim, hopefully we go another summer without it.
Together, we for another pair.
I don't know.
Welcome.
Standards are,
Well, they've done. Thank you for being here.
thank you, Mr. Chair, Sarah Copeland-Hanses, Vermont Secretary of State. And I want to say thank you to you all for taking up this important issue today. I will be fairly brief. And, if you find that you're diving into this further later on this week or early next week, we're happy to come back and dive into things with you. I think that given the moment that we're in and the heightened tensions that we see in political contexts around the world, around the country, I think it's really helpful to have this put into Vermont statute. There is nothing that's more important and more central to our office than ensuring every Vermonter's right to vote and ensuring the safety and security of the people who are helping to conduct those elections. I think it's important to note that within our state, as well as across the country, there have been numerous instances of people who have been threatened and indeed property damage and individual threatening, not only in polling places, but in people's offices, in people's homes. And I think it's important for us to be very clear about what the consequences will be in the event that violence is used as a way of interfering with elections and the conduct of elections, or with interfering with somebody's right to vote. We at the Secretary of State's office, have a front row seat to stories that we hear from other parts of the country. But we are not immune to threats of violence within the state of Vermont. And indeed, after the 2020 election, the threats became so egregious that it caused psychological harm to members of our staff. And I have made it my goal from day one to make sure that nobody who is working in the elections realm to help us conduct our democracy is put in harm's way like that again. And I think this is a really important step. It's an important tool to be given to law enforcement in Vermont to be able to protect these people. It also dovetails very nicely with the work that the legislature did in forbidding carrying of firearms in polling places. We know that there is no place for that kind of threat or intimidation, and this really just ties a bow on it and makes it very clear. So I want to thank you all for taking up the bill. Thank the sponsors for crafting it, and we are happy to take questions. I have my Deputy Secretary Lauren Hibbert here with me. I have my Elections Director Sean Sheehan with me. So if you have any questions for us, we're happy to take them.
Question, Karen.
Thank you for being here. Yeah. So I guess I got a little bit this from Ledge Council. So there's federal language on this, and we're kind of taking that and putting it here to make it so it's applicable to our state and municipal. So are there no protections right now? What if this happens right now? Is it what? what would happen?
Well, we don't have explicit protections. And I think the fact that those protections exist in federal law would require a federal law enforcement agency to care enough about what happens in Belvedere to come and investigate something. Sorry, Belvedere, I did not mean to pick on you. It's the first name that popped into my head. But you understand the point that, what happens in one place in Vermont might not mean a lot to, to a federal law enforcement agency, but it does mean a lot to us in Vermont. And we know that the threat of violence can be an intimidating factor to make people who are vulnerable in other ways feel uncomfortable exercising their right to vote. So I think it's important that we have these protections in state law.
Yeah, no, it just is interesting for me to learn that it's a gap that's there. So thank you.
Representative Oliver and then Representative Burke.
Thank you, Chairman.
Sir.
I'm just curious, what's like the most common type of interference or something you see that? Concerned about?
Well, I can talk a little bit about the specific things that we have seen in Vermont. There was a swatting incident that attempted to call law enforcement to my home before one of our 2024 elections. If that had been successful in deploying law enforcement in the backwoods of Orange County at 7 a.m, I might have been interfered with on my way to the office on the day of an election. We do hear stories from town clerks all the time about angry people coming into their office. People who may hear a news report from another state, or they may hear a conflated story that is an amalgam of things that may or may not have happened in other places, and they direct that anger at their local town or city clerk. In fact, we've had a number of town clerks' offices in recent years who have closed to walk-in traffic so that there isn't the opportunity for that on a daily basis. And I think what is important about this is that it will ensure that not only in the preparation days before an election, but on election day, there are some specific protections for the people who are conducting these elections. Some of our small towns, I forget where you're from.
Sheldon, Swanton.
Okay. Swanton. Yeah. You're from Swanton.
No, I live in Sheldon.
Okay. I love Swanton. I love Sheldon too, but I haven't spent as much time there. But some of our very small towns, as may only have 1 or 2 people working in the office, and they may only be open 10 or 20 hours a week. And that can be a very scary and lonely place. In fact, I was approached by an assistant town clerk in a very small town in Vermont who carries a firearm with her to work for her own safety, and she was really worried about the barring of firearms in polling places, because she said, this is what I use to protect myself. And so, clearly, if there are people in town offices who feel that threatened, that they feel like they need to carry protection, they must be having some incidents that I haven't heard about.
Not necessarily related to voting, but there can be a lot of things going on in town.
For sure.
Yes.
For sure. Yes. But I'm in charge of elections in Vermont, and as such, I feel like it's my duty to stand up for the protection of all of the election workers across the state. And if people are grumbly about having to pay their property taxes, I feel for them, but but I can't help with that one.
For the feds to get involved, would it have to be a federal election?
Yes.
So the larger portion of the elections, they pay any attention to it anyway.
Right. Even if it was a high enough profile incident that it garnered federal attention, if it was something that happened at a school election or a municipal election,
Right.
That wouldn't be their jurisdiction.
Other questions?
So I had a question. I'm not sure it's for you or for Tim or Sean or Warren, but I'll ask anyway.
Yeah.
So the issue that is on the other side of wanting to protect voters is First Amendment protections. We haven't really talked about that, and I guess this may be more of a question for Tim than anybody. That we modeled this under 18 U.S.C. Section 594, intimidation of voters, and it's very much matches that, very close to that. I think in part because that law's been out there, and I'm not sure if it has been challenged. If anybody knows if it's been challenged.
I have to look.
Yeah, so we need to double check. The question is, this is a little bit different than a normal criminal threat, where you have to have a true threat, as it's called, where somebody actually is feeling threatened that they're going to have serious bodily harm or death. And this doesn't do that. It doesn't quite go to that level, I don't think. And I'm just, putting out there, is there a constitutional question? I mean, there is a constitutional question. Has it been answered with the federal law already so that you don't have to worry too much about that? Although it's certainly something we have to look at. I don't know if anybody has more input on that.
We'll look to the attorneys.
Okay, well, we will.
That is a great question to explore. I appreciate that.
Yeah, we'll do a little double check there. Any other questions? Are we gonna have Lauren as well, or is it, she was just here?
Sorry, she's just the wing woman.
Okay, well, that's it.
Great role. She actually printed me a copy of the bill, so it's pretty essential.
Tom, did you want to weigh in on this at all on behalf of your?
I appreciate that, Mr. Chairman. I guess I'll just say for the record very quickly, Tom Adlenor, Legislative Coordinator of VSEA. But I would very much want to echo the Secretary of State's comments about this and thank her for her sensitivity to and dedication to addressing these issues. As she alluded to in her testimony, our members at the Secretary of State's office have been subject in the current climate, even before the Secretary assumed her role, to a very concerning and very harmful amount of threatening, harassment, and other issues that had led to people in that office feeling deeply concerned for their personal safety. And although the important questions about whether or not our democracy can properly function if we're in a climate where these threats are commonplace and not sufficiently being addressed is an important one. From our perspective, it's a substantive and really important labor rights issue. People should not have to be afraid on the job. And unfortunately, given the current climate, it's an increasing occurrence around the country. So we're very, very supportive of this legislation and hope that it will pass.
Appreciate it. Thank you very much, Sarah. I guess
There's
that's.
one other thing that you all haven't asked, but I want to offer this as my opinion. There was a question about this enforcement language and the fact that there is enforcement language in other parts of Title 17. There are aspects of this enforcement language that close some loopholes that exist, or some it makes slight improvements to the language that exists with respect to enforcement of our campaign finance laws. And so if the committee had the time to give it the attention of extracting and putting all of the enforcement language in one place, our office would support that, and we'd be happy to work with you on how to put another draft in front of the committee if that is the committee's wish.
So the preference is to put this all in one place.
I think it makes sense, yes, because there are aspects of this language that I think were drafted in collaboration with the Attorney General's office that help to ensure a bit more transparency into the process of how investigation and enforcement happens.
Okay. All right. We'll have to think and talk about. I can take you up on that. I mean, I guess, well, we have time because I have more witnesses between now and 3 o'clock. So somehow some of our witnesses dropped out. So I could ask you to work with the Attorney General's office and our
We'd be happy to do that.
counsel to
Yes.
put this into one.
My wing
Is that
woman
our
says
preference?
yes.
So we're gonna pull the other enforcement language from wherever else it is, squish it all into this one, so it's all in one place.
Right, right. Karen,
And I'm guessing then we would need, is that under GovOps? Purview, thank you. So we'd need to do maybe a drive-by with them.
yeah, I think they have to do a drive.
Okay.
Yeah, Lauren.
I could just say for the record, Lauren Cooper, Deputy Secretary of State, there's really 4 different types of investigations under Title 17. There's, well, if this law passes, voter intimidation, civil investigations. There's lobbying investigations done by the AGO. There's campaign finance investigations done by the AGO, and there's election fraud investigations done by the AGO. Right now, the language that is substantially in the bill, although improved upon in this bill, is only in the campaign finance section. And it does create some issues when the Attorney General's office is investigating lobbying and election fraud. So if we could have one section that is commonly referred to, it would be cleaner from a statutory perspective. It would unify the process and it would cover all 4 types of investigations. So I would love to be able to work with the Attorney General's office.
We only have, I don't know, 1 week? No, 8 weeks. I dreamed last night that I had 1 week left.
Is that like waking up and thinking that today's the day of your final exam and you haven't gone to class and you haven't read the books?
I was lying.
I have those anxiety dreams from time to time as well.
But the funny thing was that in my initial reaction in that dreamscape was, a little anxiety, and I said, well, what the heck? But we could.
Yes.
But we do have, I don't know, 8, 9 weeks, something like that. So if
Yes.
you can certainly move that along.
I think we can help you beat your
We'll put
8
it
to 9
on
week deadline.
pause. Well, we won't completely pause it because we have some additional testimony we are going to be taking. So
Yes, it should be a fairly straightforward fix, and we're happy to collaborate.
you didn't say simple, so you didn't completely curse it.
No.
Is that the same? Did you curse it when you say straightforward? Or is it?
No, no,
Simple?
that has multiple, many syllables, so we're good to go.
If you learn not to say simple, when you
Right,
use in the
right,
legislature.
yeah.
Don't ever say simple and little in the same sentence or
No, that
for sure.
destroys it. Okay, thank you very much, and we'll
Thank you.
put this on pause except for the additional testimony we have scheduled for tomorrow. So,
Wonderful.
and that might give us a little better chance of getting the right clerk in, because we might not have a clerk to testify.
Well, if push comes to shove, I do have a meeting of a handful of clerks coming to my office next Tuesday. So we can always arm twist them to come and join you if you haven't found anybody before then.
Okay, great.
Wonderful.
Thank you. All right, so
Can I ask one question?
yes, that's all the questions. We have an hour and 15 minutes.
I could probably take that long, but.
Thank you.
The penalty, the 2-year misdemeanor and $2,000 fine potential, is that just sort of mimicking the criminal threatening?
It is.
Okay, so the federal language that we're borrowing is a 1-year misdemeanor.
Because I think they only have anything over a year.
Is it penalty? So I just think like we could consider a felony if we wanted to, right? I don't think it has to mimic the criminal threatening statute as far as the penalties go.
True.
So I just
Proposing to, is this because you've become a deputy?
No.
That now you want to work?
Well,
on things?
I don't know. I guess I don't know if it should or not, but we just put it in here, borrowing the criminal threatening language as far as the penalty goes, and I just wanted to at least.
Yeah, is it the appropriate penalty?
Is it the appropriate penalty? It probably.
Were you gonna say 6, 7 just now? You could have looked like.
Oh,
that. 6,
no.
6, 7 years.
Martin's calling it out. I gotta tell my kid.
Yeah, I know. If I'm
Don't do
calling
it.
it, it's done. I didn't do it. I just was wondering if he was, as a youngster, was going to do that.
As the junior member.
As a junior.
The JD.
So yeah, we do have to look into make sure that the 18 USC 594 hasn't been ruled unconstitutional, but
Yeah,
I think that's, you know, we could spend some time talking about what we want to do with animal cruelty, or do we want to wait until we have our additional couple of witnesses before we do that?
I would love to have a little like compare notes session
We could do, I mean, we have some time. I think that that wouldn't be a bad idea,
to
given,
move it along. I mean, otherwise. To people to-
We could find a witness for you to ask if they would like to be informed.
Yes, if they prefer making informed decisions or not.
Yeah.
right. So, yeah, let's walk through and kind of see where we are and see where the questions are, and we can even start having somebody working with Eric on drafting the next version. So why don't we just walk through? So I'm on page 2, and I have that we need to add the without a bona fide veterinary or animal husbandry purpose to D. Yeah, I think that's not controversial. I thought everybody sounded like.
Thank you very much.
Right?
Yeah.
Thanks, Tim.
And the idea here is that, like, insemination in
Artificial
partners is like could totally fall within that. And so, yeah, okay.
So the next thing I had at least is on page 5. Does anybody have something?
Something that I marked on page 1.
Oh, wow, okay.
It's a general question, that's why. And I think it was my seatmate here that said, would this be a sealable offense? And if there was any cross-reference or anything we needed to do with that.
Well, I think it's already would or would not be sealable.
Based on what it is.
I mean, because if we move it to the felony, you know, the aggravated is a felony and that's not sealable.
Not sealable, so.
I mean, yeah, so,
Right.
right? I mean, because if I'm remembering that law.
I wasn't remembering it
We have a
either.
list of felonies that can be sealed, right?
Correct.
That's where we ended up.
Yes,
So, and we don't have that one on the list, I don't believe.
so perfect. Should answer.
Yeah. All right, so I'm on the page 5 and I had a couple of, well, I had one change and one thing that I think is a question out there. And, well, I had a couple questions, actually. Should we put G also in the aggravated? In other words, that there's this possessions, films, distributes visual images of a person engaging in sexual conduct in the presence of a minor or something like that. That I know that came up yesterday.
Yeah.
Yeah.
Say that again?
Yeah.
So essentially taking G and also adding it to the aggravated component, but it'd be with the minor as well. Because we essentially have all of these in the aggravated for the sexual conduct with an animal. It's just that it involves a minor in some manner. Except we don't have G in the aggravated.
Which seems like an oversight.
Yeah, it's just, the language would have to be a little bit different than to make clear that it's, you know, involving the minor.
And like, just thinking about it, like,
So that,
could it be aggravated?
Yeah, I'm just trying to-
If a child, this type of material?
Right.
Probably, yeah.
Can I add one piece to, are you in the middle of a thought, Tom, that you'd rather me not?
Yeah, just real quick.
Yeah.
So G would include filming somebody, having sex with an animal.
so. Yeah, so we're gonna add, this is language you weren't in that, Judge Zone said it should say a person engaging in sexual conduct.
Oh, okay.
So that
Yeah,
clarifies that.
yeah. No, because I was just worried about, I mean, because when we did, sexual abuse of kids, that type of thing, was with, you know, with the pictures and whatever, and I was just kind of putting them together. Just thinking if it's just a picture of an animal and somebody suggesting they're doing something, but I'm good with it.
Yeah, saying engaging in sexual conduct, that
Right,
covers
if
it.
they're engaging, that's good.
And I guess the other issue was AI, whether this covers it.
Right, which, I mean,
He said artificial
I
representation.
think that's a completely important case.
Say we could add visual representation.
it's in,
It's hard.
it says
Right?
that visual images. He said we could consider adding something about
Right.
digital or digitally created or whatever, but
You don't need to? I mean,
He was-
I'm looking to you as my expert on.
Well, I was gonna, I mean, I think visual images captures it.
Yeah. Yeah.
We're not excluding digitally enhanced or created, we're just saying all visual images.
You'd want to clarify?
Oh, no, I just don't think an AI generated image is image of.
Right.
It's a visual image.
Is it a visual image of a person engaging in sexual conduct with an animal?
Do you want to say visual image or depiction?
So
We should
So
look
if I
at,
draw a picture,
Yeah, that's a visual image.
so that would be a felony.
If a kid was.
If you're
If a kid was present.
present, are
Right.
you gonna charge it that way?
Well, no, I'm not actually trying to say anything. I'm trying to clarify. So,
Yeah,
so
yeah.
I'm just trying.
why don't we look at the ICAC law that we did this like last biennium where we talked about AI created, I think. Am I misremembering that?
And I don't remember if we did AI. I remember we did something around somebody not necessarily engaging in sex with a child, but and the thing that I remember talking about is the picture looking at a child from the back with somebody in front of them.
Yeah, no,
And
I
it
think.
looks like they're touching them, but might not be. So we did something around making that unlawful, but I don't remember the AI.
Well, let's
Yeah.
double check.
'Cause I don't think we can do AI just because it's
Well,
be considered art. I mean, it's.
Oh, wait, you went
I
through.
mean, AI, well, we have, like nudification. That's a nudification and uses artificial intelligence to take a picture of someone who is clothed and take the clothes off of them. But we can say that that's not legal, but that would be a visual image of a naked person without their consent, and I think, and I want to say in general, that I almost want to avoid the term AI or artificial intelligence when we're trying to make this clear, because AI is a marketing term. You can use the tools that make AI possible to do lots of things and not call it AI. So I'd want to just be using very broad terms. That's why I like visual image, but
I want to make sure it's encompassing of
Yeah.
everything.
Yeah. What are you thinking?
I think it's real messy. I think it's really messy.
yeah, it probably is one of those things that will have to get sorted out through case law.
Yeah. I would almost be like, let's just not touch it. In the sense, let's just make it kind of leave it where it's at.
Visual image.
A visual image. And I would argue that a artificially constructed image is not a visual image because it's not of the thing. It's it's not a picture of but again.
What's your defense attorney?
Yeah, I think
Well,
that's why image is I think a better word than photograph or,
Right.
Because of the work we've done in the past, I agree.
Yeah.
And if we,
Not that I like it.
No, well,
if we specify it in here and we don't in other laws, I'm also worried that's gonna backfire. That means that that it's okay in the other laws, because we don't have anything.
I'm trying to find it,
So
yeah.
can we just put that more, we need to look at things more on that one and move on?
it's for
Part of
like-
me reviewed.
We're getting into a deep dive onto AI.
I mean, that's where we're going.
I mean, it's already derailed the moment we brought in ceiling exposure.
So I think
That was me.
I think we should look at what we did last year with the updating the revenge porn statute too, and
Right.
but
Any
But-
witness that we could bring in to
I think-
opinion on
I
it?
think the AG's office they've spearheaded the digitally created image.
And your point is really well taken, but I just think it's conflating two things. Because I think taking an image of someone and using some sort of process to change it and then using it in some way, very different than in my opinion, a totally artificially constructed image of a made up person, not a real person, having sexual conduct with an animal, a made up animal, all that's fabricated. Right, that to me is a very different question as to whether that's an image of this than your example of taking a real life photo of someone and then artificially changing it.
what, yeah. I mean,
they're like,
because you can do the same thing with humans and make an AI generated porn with an image of someone
Yeah.
not engaged in a sexual act and make it so that they're engaged in a sexual act, like you can manipulate things as long as you have
yeah,
like one
yeah,
piece of visually available, a visual image of it, like you can do anything to it now.
Yeah.
So,
yeah,
yeah.
Yeah.
Yeah, I hear you.
So
But I have a question so
before we
yeah.
finish that really quickly, I think we probably just need to maybe try to get some consistency on how we're dealing with images, because I'm looking at possession of child sex abuse material and they use different kind of language there. And so I think we want to have, well, it says knowingly access with intent to view any photograph, film, or visual depiction,
I
including
suggest
any depiction that is stored electronically. What's that? Yeah.
I suggest the task force to look at all legislation.
I
Well, no,
will.
we should, to the extent that we can
and
push towards consistency.
Yeah.
And the intent is, I think, really important. That, having intent language in this one makes a lot of sense.
Yeah, right now it's possesses, films, or distributes. All right,
I like visual depiction, but that's broader than visual image.
right.
Yeah.
So we will sort that one out. What else did you have? Something else? Like that?
So in that same section, a witness mentioned yesterday that 5A and B, page 3, 5A and B,
Page 3.
yep. Line 7 through 14, these two having to do with fighting, animals who are engaged in fighting or training to fight. The witness offered that those should also be included in the aggravated if it's in the presence of or involving a minor. And I just wanted to throw that out to the committee.
Where are people with that?
Can you repeat that?
Yeah, so on page 3, there's this, this section is, the misdemeanor cruelty to animals. And then we have the aggravated cruelty, which to construct the aggravated, we've basically taken almost all of the same, examples or circumstances from the misdemeanor and pulled them over to aggravated by adding, in the presence or of a minor. What's the exact language? Yeah. In the
minor
presence of a
language.
minor or in which a minor is a participant. So the suggestion by one of the witnesses yesterday was that 5A and B should also be brought over to the aggravated section when done in the presence of or involving minor.
With other crimes. Because again, I'm just worried about consistency. Like if this is gonna be one of the few laws that we don't, that we add it, like why?
Because all the other ones are related to sexual conduct that
Right.
involve a minor, and this one doesn't have any sexual conduct involved in it.
And there are a couple other things in existing law for the aggravated that don't have to do with sex. So,
That have to do with in front of a minor.
no, that are just, you kill a service animal.
No, I was talking about just the adding with a minor. Like if you rob a bank
That's
with a
a
minor.
different question, right?
Oh, I see.
Like sometimes when we come up with new, like,
Well, I just want to hear if anyone, I think that's important. And I'm wondering if we can just deal with just 5A and B first and see if there's any interest. Or I don't know how you rule, chair, majority interest. I don't know what it is. I just bring it up because one of the
Right.
witnesses flagged it, that doing those things in the presence of or involving a minor is also.
If you read B and you stick in the presence of a minor at the end of it,
I don't
Yeah.
feel strongly on that one.
Okay. Yeah, I mean, they're very different.
transports an animal with the intent,
Okay.
that's at least my read on it, but.
Yeah.
I would agree. Feels like a consensus is reached.
Yeah. Okay.
So back to your question.
So are we done with page 5?
it depends on if we're.
We
We
were-
were just talking about B, right?
A and B.
Oh, I didn't realize you were talking about A too.
A is a little, a little harder, but I think that they kind of both, I feel the same way about it, that it's kind of doesn't feel quite right.
I mean, I don't recommend people do it in front of it. I mean,
No,
No, I'm not explicitly saying that you should.
all right. So I have the next thing on page 7.
Yeah.
You know, and this is what Lisa actually raised with respect to subdivision 4B. That a person can repeatedly get tickets, and I mean, this kind of is a new thing. I don't know if this is the time to consider it, but I'm guessing she meant to that if somebody keeps on getting these tickets, then it should be elevated to
Right.
actually a criminal charge.
Yeah.
I think that gets awfully tricky, but why don't we see what language she gives us from that one, if she gives us any language? No.
If you follow something like we do with traffic laws, civil violations, you can start with civil violations in the realm of PLS, for instance.
Yeah.
And after X number of convictions, you can go become criminal. You can make that whatever you want, and you can increase fines for the offenses.
she was worried
And it's a
about,
way to track it too without having a registry or.
she was saying if people are getting tickets in lieu of criminal charges, it doesn't prevent them from owning animals.
Oh, there's that as well.
Right, but you could also like suspend their ability to have an animal.
With a civil ticket?
Well, you can take away people's, well,
Maybe it's after
So-
the first ticket.
So wouldn't law enforcement, they would look on the system and see that this person's been ticketed 4 times already, and they might think, well, I think I'm gonna charge them this time. I mean, isn't there some discretion exercise?
there could be discretion, I suppose. Well, if it's the third offense, then it would be a third offense in the statute. You know what I mean? Whatever you,
How would you see, so for the DLS, right, you see the 2 civils within the last 5 years, you see that in there.
we calculate, we make the determination ourselves.
You pull that from their driving record. How would you find this civil ticket?
They did it in the civil system, it could still show up in the driving record, just like kid with alcohol.
So we would, pull their driving record to see whether they have an animal cruelty.
Well, it'd be a ticket, civil ticket.
A civil ticket. Oh, they're just like a civil ticket, you pull like a record, okay. Huh.
I don't know how White River and the traffic bureau.
Do you wanna, can we talk about it for a second? Or I'd be interested to see the language, but I think I sort of fall more on the line of not, because sometimes this is basically penalizing someone who just doesn't have the money to pay a ticket.
Well, I don't think that's
Why would they get another ticket?
handing the ticket. That's not where the issue
Well,
is.
if you followed what we used to do before, where if you don't pay a ticket,
Yeah,
would definitely go under suspension. So if you're not paying the fine on this, you would lose your ability to have a dog. I don't know.
Yeah.
I misunderstood
Well,
what,
I also think the last sentence kind of is the saving clause for this, that it states, the state's attorney can say, no, we're charging this guy under
oh, yeah.
30, 50.
These are done in a traffic hearing with the officer, the person, yeah, so it would be pretty, the judge could do whatever they feel necessary.
So we'd
If they
be
fought it.
I think we leave that alone.
taking discretion away.
Not necessarily, well, yeah, some.
So this is, it's interesting though. Like, I don't understand how would that function though?
How would that
So the
happen?
state's attorney may withdraw the complaint filed with the judicial bureau. So somehow it's brought to the state's attorney's attention that there is this pending civil ticket, and they're like, oh, no, we want this charge. Like,
Aren't you looking at all the tickets?
Every day.
but I guess that's how it would happen though, right? It would be pending and.
Right, or somebody raises the fuss that, what, this guy has a ticket?
Yeah.
Can put that, if someone raises a fuss.
Yeah, fuss was.
I definitely want that in
That's
there.
implicit. It's implicit in the language, I think. So,
Okay.
I don't know, I think I think we have enough on this to figure out without figuring that out. It's kind of my,
Yeah, I would be
Suggestion.
curious to know.
Give you the opportunity to have a lower level violation.
well, it's now, yeah, that's what they have now for, yeah.
I would like to know if this is happening, if there are people who, if you look back at like
Well,
the
there's
big
actually-
cases, that. Right, would you say, oh, wow, they actually had 4 tickets.
So do you want to ask CRG if they can, if that's a possible thing to find, is that this happening? Because I assume you're going to ask CRG about the other question you had, that Judge Tony said go to CRG, yeah.
Sentencing info,
Yeah, yeah.
I think she was referring to a different state she was talking
How I heard it is that, for people who are getting multiple tickets, that it would
about.
like to
What
be
civil
like,
ticket do we have for,
whatever it is.
This is existing law.
what ticket do we put that?
No,
I don't even know.
That's what I'm saying, like,
Yeah, maybe this is-
People are not doing their jobs.
Because there's criminal tickets, which are from Vermont Fish and Wildlife, and there's civil tickets, which are what we handle
Yeah,
in standard, well, whatever, normal law enforcement, but. But Fish and Wildlife doesn't necessarily handle
Domestic.
these type of cases because it's not wildlife.
right, it's you.
So-
The law enforcement, can give a civil
Right,
citation.
but what title and section? I'll look it up and see if it's in the schedule of fines. I don't,
It's 13 VSA 353.
Chapter 8,
what is it?
Chapter 8,
Who introduced this?
No, what
now?
title?
Title 13,
Oh,
Chapter 8.
Section 353.
I'm looking at 352 first, but it's the,
353A, 3, 4, or 9 to be precise.
okay.
That's helpful.
Okay, can we move on and then
Yeah.
we'll backtrack to that one if necessary? All right, this is the trickiest one, I think. Well, besides having to completely rewrite the other. This is actually for some decisions that people may have different viewpoints. I,
Because we don't have different
We
viewpoints
do.
on other
like,
things.
for instance, I definitely don't like the shell, at least the way it's set up now.
We just do a vote
Can we-
right now.
Yeah.
So I could do a may for B1 and B3. But not B2, 4, or 5.
Oh, we are on page 8.
We're on page 8.
We're on the, we're on the like, the shell. So can you just repeat
Yeah.
that?
So I mean, I could see doing a shell for B1 and B3. But B1 and B3 also have to be worked on a little bit. And not for B2, B4, and B5, it would be a shell. I mean, a may for those 3. You still don't like it even then. But let me put the next thing on here as well. Here's my next suggestion is that a misdemeanor, first misdemeanor would be 1 year. A second misdemeanor, second and subsequent, to be 5 years. And for a felony, you could do a 5 and 10, first, second. What she suggested, and which I think makes a lot of sense.
Still with a may?
Well, it could be a shell. I mean, so others. I started looking at some of the other states of the Animal Defense Fund. They haven't. I figured that you were doing all that work, and instead I did that. But there's a really good, an excellent, actually, website that shows the whole country, and then you can click on, you can see if you're one of the mediocre or one of the good states for animal cruelty laws. We're mediocre. But you can click on the states, and then it will give you all of their laws. And so I looked up a few. I looked up Oregon, Louisiana, and one more, Virginia. And they all completely have different ways of doing it. Some are saying it will be, the ban will be up to 5 years or up to 10 years rather than a minimum.
Yeah.
Others actually have like a minimum, but they have different minimums depending on if it's a misdemeanor or felony. I mean, I could be okay. I mean, I could be okay, but I don't know where other folks are as far as having shell for B1 and B3, but with the graduated penalty, depending on whether it's a repeat offense.
That would be like, I wanted to roll it back, so I would probably, I feel like I'm on the end of like maybe rolling it back the most, so I'm happy to, I'm happy to move where we can get the committee to go.
And we kind of need a 4, which she raised afterwards to me, because I was talking to her about like people who are in business dealing with animals, like this doesn't stop them from being in business. And that's been one of the big problems in Vermont, is people who are like pet groomers or do pet boarding, but they're abusers. So we need to also have forfeit any, like,
Where you just, that's on 3, number 3 down, okay, yeah.
right, like, so we need a 4, like, to have, I think she said, like, operate a business that, or operate or work in a business that interacts with animals.
Would that be caring for an animal?
I don't know. I mean, if you're a pet groomer, are you caring for the animal? And like, those are times that people have the animal to themselves. So it gives people opportunity, like the child abuse laws, if you get convicted, you're not gonna work at a child abuse center.
Right.
Yeah.
So what would the language be? I mean, essentially, are adding a verb, work with, or something.
Let me just
I think
see. I wrote down a
part of
word.
my overall is like, I do feel like there should be chances, like that you can learn from things, that you can build from, and it's on the severity of it, so. That is where I tend to
So
lean to.
let me add the additional thing I hadn't gotten to yet that I was going to suggest that we do. Actually, there's 2 additional things. One is an opportunity, not for the 1-year thing, but for if somebody is banned for 5 years or more, that they can move after a certain time to lift that ban. And you know, essentially being, and we can, there's one of the other laws had, well, here's what you have to show to be able to lift the ban. It could be successfully completing one of these things. So that kind of gives you, that makes me be able to deal, you know, have the shell for a 5-year or even 10-year if it's a second felony, if there's a way out that the person can, you know, go after. But yeah, Ian, that's
I'm like, totally needs to go back to May.
okay.
Seriously, like I really think that taking the options away from the court to make individual rulings on these individual cases is really problematic. And I think the result will be these cases will all have to go to trial. Like you're not going to get a resolution that is agreed upon between the parties, because they're going to have these really extreme elements to the plea agreement, no matter what. And so there's not going to be any room for negotiations. And when you protract out these cases to go to trial, that means the dogs are held in the weird forfeiture limbo for longer, because it takes a long time to take cases to trial.
Right. That's a good point too. But is it different if we're talking just those 2?
I would say those are the 2 most extreme ones, right? So one is that they have to lose the animal and all of their animals. And they're not going to be able to possess any animals for 5 years.
No, I'm saying 1 year if it's a first misdemeanor.
Okay, still.
Is that still not, you're not going to.
What I don't understand is why not let the court.
Because apparently they're not doing their job according to some of the animal rights people.
We heard that. Yeah, I don't know. I mean, like, I just think like, kind of like why we don't have sentencing, mandatory sentencing in Vermont is because we believe that case by case, you have to sort of assess the facts.
All right, well, let me throw this out there then as a possibility. Yeah, I'm fine to go to May as well. You know, I'm just throwing out a way to go to shell. So I was asking Zone A, and I don't know if I was probably wasn't articulating it very well, just like I'm not now probably, is that are the courts, when they're doing a sentence, they say there's a probation of 6 months, they say, well, I'm going to have them ban possession for 6 months. Because should I make it clear? Should we make it clear? And he says that it's clear because he's saying a period that the court deems appropriate, but make it even clearer, you know, like that for a one-time misdemeanor, up to 5 years, for repeat misdemeanor, up to 10 years. So have the way we normally do sentences, but also making it clear that, yeah, your probation, it's maybe a misdemeanor of up to 2 years or up to 2 years, but you can keep the pet away from for up to 5 years.
That makes a lot of sense to me.
So, I mean, you're kind of signaling that, and we're doing something more here.
Yeah.
Can I just point out that I agree with this, and I feel like we are missing a lot of folks in here, so just how we're going to circle back with that, and I don't know if others have other opinions on it, but I just want to make sure we're not going all in on something that we're gonna have to retract.
No, and I guess like I can see the argument the other direction. I guess like the one thing I would put to the committee here is, and we even heard from witnesses that there were situations where, like with proper programming and stuff, animals were returned to owners. What I think you need to ask yourself is, do you think that there's ever a time when someone is convicted of an animal cruelty charge that it's not like that it would be appropriate for them to get their animal back? And if you can think of any example where that would be the case, then you can't do the shall.
Right.
But you can't do the shall because then you're taking away that option for the court to not take the animal away.
But for the commercial, for the job with other people's pets, I think it could be the shall, because
I don't know. I mean, that's one of the reasons why you don't mandate, because there are 1,000 different potential fact patterns about how an animal cruelty charge comes through.
But if I found out that somebody had been convicted of this and I brought my dog to be groomed and they abused my dog, I would be like, it feels. There's no registry you can look at, like, is this person a safe place to leave my dog for the week?
Well, we could create a registry too, but that might.
Yeah, let's throw that in.
Some other states do have registries.
Oh, really? Do the other states have have some do?
Yep.
All right. I
We
mean,
share that website.
Yeah, share that website.
I don't know.
Thank you for.
I mean, that's like, I just like how I feel about it, but
So we're gonna hear from the Defender General's office. No, we're gonna get written testimony. I won't be surprised if they suggest that on this particular part, we want to take it as individual defendants. That's the way we should be doing our criminal law. We should certainly have some penalties and some maximums, but you got to take them as individuals and their individual situation. And I agree with that. And so this one, we're going to have further discussion before we do anything with it. How about that? Because you're right, that more people need to weigh in. But I do want to just throw out there the fact that if we're going to have something where somebody could be barred from having, if it's going to be a shall, I would want to have a motion practice set up where they can get rid of it. But if it's going to stay a may, I don't know that we need that so much. Maybe we do if the judge does sentence the person to banning them having an animal for 10 years. We allow them to. I don't know that I would bother unless it's a shall.
oh, if it's not a shall and it's just a may.
It's a may. I don't know that I would. So the other thing is that so we talked about checks during possession, the number 5.
Right.
This is one of the things that she brought up. I find that's missing here is, what if the person's banned from having an animal and they have the animal? Shouldn't there be a separate penalty for that?
And they should be checked.
You have violated that ban.
Right.
That should be an offense.
Right.
So it's kind of like they're on probation.
I don't know if it's a violation of their ban on possession, whatever you want to. It's a VP.
So that, what would that?
So what are they going to be in contempt? I mean, what would be the consequence if? Well, no, I'm going to have my dog.
I mean, I guess you could add a subsection into animal cruelty, one of that being you possess animals when you are not lawfully allowed to.
That's what I'm suggesting.
Yeah.
Oh, I'm sorry. I'm slow. It wasn't.
Yeah, that's what I'm suggesting. Maybe we just add that to animal. Do we add it to animal cruelty, or do we add it here to the penalties that we're talking about?
Well, I think it'd be pretty easy to add it into the actual animal cruelty. Like one of them could just be owning, like possessing animals when you are not lawfully. Right.
I think so.
Or I don't know, yeah.
How do we do it with firearms?
There's a separate offense that, yeah, prohibited person.
Yeah.
Do you want to make it aggravated if you unlawfully own animals in the presence of minors?
And we are live here, just in case you have any,
I noticed
it's just, yeah, so you never know. All right, so we're gonna have more discussion on that, because we need to, I know there's gonna be people have other folks
So,
in here.
but are we in agreement that we would add in 3 on the bottom of page 8, add reside with or cohabitate with to the forfeit any future right to own, possess, reside with.
And work with, is that?
I sent, there's very specific language.
Oh, okay, you said that's the language that you said, okay.
That's the language that I sent. This says, be prohibited from working in any capacity that requires such person to be in contact with an animal, including a commercial boarding or training establishment, shelter, animal control facility, pet shop, grooming facility, commercial breeder, veterinary hospital, clinic, or animal welfare society for the purpose of providing and promoting the welfare, protection, and humane treatment. That's Massachusetts language.
That's like its own separate.
I feel like it is a 4, not.
Right.
Right.
Yeah.
And maybe it's too long, but.
All right, so we can look at that language with whoever's shepherding this can. Language.
Animal bill.
What's the sponsor?
Shepherding, it's shepherding.
Yeah.
I'm sorry.
Good.
I didn't
Oh.
realize I was saying that.
And then before we move off the page, but not dealing with may and shall, what about this livestock situation?
Oh, yeah.
Oh, wow.
I don't fully
I know.
get it.
I know. Fascinating.
I like the suggestion to use the definition of a farm. I haven't looked at that definition yet, to be honest. I should look at it right now, but that was one that Lisa offered, that you might look to some of the ag related statutes to kind of cross-reference and I would like to not exempt people with, a gentleman's farm or gentle lady's farm or whatever, they happen to collect a bunch of animals and they're not treating them well, and then we aren't allowed to remove
Right.
livestock or poultry.
Right.
Yeah.
And still protect folks who need it if this is their livelihood, and I hope then we could offer the education and all of that, but.
Yeah.
So is one way to address that is, I hate to even say this, is adding a sentence that is essentially an exception to the exception with respect to livestock? No, I mean, that you could add, except livestock or poultry, except in the situation, where it's not, I don't know.
Well, or you'd say, except livestock or poultry owned, possessed, or in the custody of the defendant, for the purpose of operating a farm, kind of thing.
I think we're gonna have to get
But I
testimony
think they were
from.
possessed or in the custody of the.
You drive by an agriculture.
I had.
There's a missing comma in
Yeah.
before own.
I think we need to check in with ag on that.
Because
Yeah.
we're trying to prevent basically someone is convicted of an animal cruelty charge for a totally unrelated animal to their
Livelihood.
farm or something, right? So
But we also want to capture they have 4 cows that are mistreating, and they're probably mistreating the rest of them, but you can't really prove it yet. Should they be able to have any?
yeah.
Right.
Lisa's presented the categories
All right.
possibility, right?
Species.
You should have all of the same category removed.
But the problem is then, do we have to create the categories of animals?
She just said same species.
Well, she said,
I'm gonna give 3 options that we could take, and that was, either categories or,
It's like a genus, but.
yeah.
you were so happy to bust that
So which one
out.
did you like?
But that could be.
Categories, species?
Yeah, where you at?
I don't know. I still want to go back and talk actually, but I'm just thinking of personal situations that I've dealt with in town, even.
Yeah.
So even kind of all the way back to, I have issues with, 3 and 4 on page 3. I mean, I feel like it's kind of subject. Number 3, I don't know, we have people in my town that have hounds, that people that are not pets. They're working animals.
So like,
And people call and complain all the time because they're tied up outside.
Yeah.
I worry about that kind of stuff happening.
Yeah.
And again, with 4, we also get a lot of complaints of people, because there's some people who just have a different idea of what's
boring cats.
appropriate for animals.
So,
But yeah,
I think number 3, though, the key is that it's inhumane or is detrimental to
And
welfare.
the definition-
So you have that.
What
It's
I'm
not
saying
just
is, especially with like animal rights people, sometimes there's like, it's a extreme what they consider inhumane.
right, but that's not the how we going to win out in court, as far as. So I mean, is there a standard in number 4? Because I mean, we do have that standard in number 3, and I think probably the court knows, and the prosecutors know how to deal with what is inhumane and detrimental to welfare.
and there is absolutely case law on.
And there's
There is
There
a
is.
law. Oh, yeah.
Okay.
Yeah.
Is there case law on number 4 as well?
To president, I'd have to go look, but there is definitely.
So would that, so would,
on,
so in the situation that I just used as an example, would that, those people would be protected and,
the tethered to the
yeah,
hounds.
so there's already case laws around that?
I'd have to look.
Yeah.
I don't really know. I just mean that the court is not just relying on this language. There's been cases on
Okay.
this kind of stuff.
In the investigation before it gets to the court. Right, that law.
Would consider that.
Law enforcement.
The state's attorney.
The state's attorney would probably look at it and be like, oh, boy, I don't know. Or maybe I'm just laying my own.
They're protecting.
You ain't nothing but a hound dog.
I don't know, but I just think I think that concern is very real, and I think that kind of leads into my these cases are
That's why
really
it should be a may and not a shall.
it's just and there are probably many cases where they should not have the dog or the animal back, or they should not get the cows, they shouldn't, all these things, but I just I don't know. Yeah.
So which is why I guess I don't know, I guess I'm not then in talking about this, not for the species, because like already if you're talking about canines, there are the dogs that you dress up in cute clothes and keep cozy in your house, and then there's ones that are working animals. Yeah. So, and that's
so,
valid, for people who use them in that way, that's,
so
it's valid.
it would be common practice.
Yeah, it's common practice.
Boy.
But like,
So we have some big question marks on page 8 there, though we do think that we should have the residing with them. To take a look at.
Yeah.
But we do need to sort out number 1, and number 3 does have to, you're not taking all the animals. If there's an exception for you're taking one under B1, that same exception can be there for B3. Oh, right, yeah. That's an animal.
Forfeiture.
You're saying you want the same, like,
If livestock or poultry are accepted, I mean, then there's inconsistency between 1 and 3.
Yeah.
Yeah.
right, you've got an exception in 1, and then it's any animal in 3.
Right.
Yeah.
Yeah, so.
Without something?
All right, so
Without something?
the next thing I have is actually on page 10 and 11, it's getting rid of having to have the veterinarian there.
right,
That made a lot of sense to me, and I guess that's just crossing that off.
Yeah.
Well,
Where it would find.
I know I missed that, what?
so I think I caught them all. I think it's on page 10, line 18, 19. Main officer shall have surrendered animal examined, assessed within 72 hours by a veterinarian licensed to practice in the state of Vermont. That one didn't seem as problematic as on page 11 at line 6 to 8. Veterinarian license to practice in Vermont must accompany the
right.
humane officer. Maybe the one on B1 is not the problem. Maybe I misunderstood.
Yeah, I think it's just,
It's the,
Well,
On
he was
page
saying it was a
11.
waste of their time in some cases.
and a barrier to seizure. They're not.
What's the line?
available.
Which line are you looking for?
Page 11, 6 through 8.
And also, I think, isn't it 12 through 15, humane officer shall immediately take an animal seized under the subject to a
She
licensed
was-
veterinarian for medical attention to stabilize the animal's condition and to assess the health of the animal.
She didn't say anything about that
I
one.
know she didn't, yeah.
And, but Judge Zone pointed out, right, that we're not allowing law enforcement to do some of these.
So Eric sent me, that actually humane
Humane officers are law enforcement officers.
isn't.
Oh, that's nice. They are humane.
We can we'll double
Okay.
check that, but I think, Eric,
But they're not all law enforcement. They're specific law enforcement.
So,
So that was something else that someone brought up that we might want to broaden. Was a different point.
And you have to pick this up, but there was one on mine, she suggested.
before we move on from 11, so you want to strike the veterinary license practice of Vermont unless it comes in humane officer during the execute?
yeah, I think so. I think that makes sense.
The only thing I wonder about that is, I wonder if it was put in place not for the vet to verify the mistreatment, but to verify the proper treatment of the animals in the process of forfeiture or
But
seizure.
it sounds like it's holding up seizures.
Yes.
And it's-
Right, that was what I heard too, but now I'm thinking, what if it's there as a safeguard for the animals? And not as
How about we change to the extent practical?
Or may.
Well, no, I think,
She had said it was pretty unrealistic to expect.
to the
Yeah.
extent practical, a veterinary licensed to practice in
May.
Vermont,
Debated in court. That was not.
must shall accompany.
What does that mean?
Almost that.
Something to argue about in court.
It's okay to consider. Can we go back to?
You don't like the to extent practical?
So someone, just to play it out for a second, defense side, the warrant wasn't executed lawfully. There was no veterinarian at the site when the search warrant was executed. Well, Your Honor, it wasn't practical to get a veterinarian there. What does that mean? What do you mean it wasn't practical? You could have called up, he could have been there.
No, I called free and none were
There's
available.
no vet for 50 miles and they were not.
I waited 2 days.
So what that says is that that's gonna put a little onus on the law enforcement to actually try to get a veterinarian.
Yeah.
If there's.
Exigent circumstances.
If you can expect defense counsel to make that argument,
Yeah, okay.
they better be able to prove it up,
Right,
right?
be able to prove it up.
I mean,
All right,
I would also
cool.
I won't argue hard for the, as if to
the
the extent
extent.
practical. I'm just sort of wondering out loud, like, oh, why would they put that in there? And I'm thinking maybe there were some seizures were animals injured in the process of
Right.
executing a warrant, and so then there was the legislature then in their infinite wisdom was like, well, let's make sure there's someone there who knows how to take care of animals.
Right.
It seems like Lisa would have been worried about that then. But I don't know.
I like the extent practical.
We can try that. Lisa's gonna get a chance to look at it again,
So,
so.
can I pick up
Yeah,
something more?
yeah.
So Lisa had pointed out that
Which page are you in again?
I'm on listening 9,
Yeah, they're like,
are
yeah.
beginning after the end of the 5-year probation. She was saying it seems important to have checks during the ban as well to make sure that they're not violating, not having the animals, not just after the 5 years.
So I think, do we need to do that if we have added a provision that says if they are possessing animals? I mean, I don't know, it's kind of like having law enforcement go out and then double check that you're obeying the law.
Or like, you're convicted of a domestic assault, and now you have a lifelong ban of firearms. There's nothing in law that is like the police come and check periodically
Right.
to ensure that you don't. It's basically, if you get caught with them, then you
Right.
get in
I
trouble.
think she's concerned that should there be a periodic checklist? What if they are back to using animals for 5 years?
Yeah, I don't think the period, I mean,
I mean,
if we were not adding this now provision that says
Yeah.
if you do possess an animal when you're banned from it, you're subject now to a 2-year misdemeanor. I would say, yeah, but it seems a little too police statey to me if we're gonna just keep on double checking that they're
If they're on probation or something, it wouldn't be unusual for a
I know.
probation officer to just, oh, there's an animal here, you're in violation.
Well, it may go past probation. I mean, it could be
Oh.
years past, so. They're not, no, that's.
Minors, even now law
Well, it could be
enforcement across the whole
that would
state.
get
I mean,
discovered in an investigation,
state
because
police
someone,
down
you
to
know, is
municipal
gonna know and
departments.
someone's gonna report it.
Right.
I don't know.
We're a small state.
Yeah. It'll resurface for sure.
Yeah, and staying on that page, can we reorder number 4? And this is something that I brought up yesterday that Eric said it seemed to make sense to him, but yeah, I mean, setting aside the fact that 3 witnesses said there are no animal cruelty prevention programs or educational programs in Vermont, we'll just
I don't know, I found some when I looked it up.
set that aside.
Online.
I Googled and I have the Vermont Animal Cruelty Education Program.
See where it's located.
Yeah, that's not a good one, probably.
Nope.
Well, I was willing to set it aside, but just the reordering of that paragraph, and I don't know, maybe I'm the only one who wants to do this, but the court may impose the cost of such programs or counseling upon the defendant when appropriate, line 7 and 8. Talks about moving that up to make it very clear, make it, that goes along with the animal cruelty or prevention programs, and then having a separate, I think like a 4A or 4i or something that addresses the juvenile situation,
And if
separating it out.
we're messing
Yeah.
with that section, we'd love to change to licensed psychiatric or mental health. I mean, I can get the language, or mental health counts, like
Yeah, that seems
This
like
is-
an update that it makes a lot of sense.
yeah.
Yeah, that makes a lot of sense. And just also another idea for the shall versus may could be the graduated, like it's may if it's the misdemeanor, some of them are shall if it's the felony.
I think that was part
I'm
of
not for
I think that
any-
was part of Martin's scheme.
No,
was
not
that? No, it
separating
wasn't.
misdemeanor and felony.
Just
Okay.
another way to try to skin the shall may discussion is there mays for the misdemeanor and then some become shall for the felony.
Oh.
I feel like we just need input on others in our committee.
I'm just thinking.
Put
like,
the options out.
Yeah, I could see that, because then it's like, okay, like you're charged with aggravated animal cruelty, probably a lot more often, these shouldn't happen.
Yeah.
All right.
Do that. Page 12?
So Vermont Law School has an animal law and policy institute.
Any classes?
You can take a class on not,
Out of the field, yes.
But I think, is there the question, I came in during this, of whether this goes to criminal or civil?
which one? What would
Or
that-
court.
Oh, yeah, civil
Whole
court.
process.
Yeah, it's
Yeah.
the civil court is what.
Yeah.
So maybe
But
pretty clear.
Are we making that decision?
For next draft, I think.
Okay.
Sure.
That's why I was so glad he said that. I was like, oh, good. It just felt very validating because when I read that yesterday, I was like, this makes no sense to me.
Yeah,
And then it allows us to go to the civil rules for a lot of the forfeiture stuff.
Yeah.
As well,
Yes.
and well, not the forfeiture so much as the service of process and such.
Getting tracking.
On that same page 12 up at the top, line 2,
Oh, right.
Lisa had recommended adding and humanely, where it says cannot be safely confined under standard housing conditions. I don't know what thoughts are.
Oh,
I haven't defined humanely anywhere. right?
Well,
So-
isn't humanely?
The
Well,
officer's humane, then,
is it not defined?
yeah, it seems like a little.
Is it?
Inhumane is not defined.
Oh, okay.
I don't know if humane is.
I think I think the purpose there is to make sure that we're not handing the main officer may arrange for euthanasia of an animal seized under this section when the owner is unwilling or unable to provide necessary medical attention required by the animal for the care, or when the animal cannot be safely and humanely confined under standard. Yeah. I don't have a strong opinion, just like that was one other note.
I mean, should we add, I mean, this is kind of to get us the next draft and have people weigh in on it as well, and we can.
Okay. Yeah.
Is there a venue line in here about like where, so it's a civil case, is it in the criminal court or is it in the civil court?
Oh, we're talking about having the civil division, right?
It's
Yeah.
The civil court.
There's mentions of it.
Are you talking the civil forfeiture?
The civil forfeiture, and then, so is that what we're talking about, changing it entirely to civil?
Yes.
Yeah, I think so.
And is it
Well,
12,
that was
page 12, line 11?
strong input from zoning.
So, yeah, so then. Okay.
Yeah, no, that doesn't work.
Well, I just like hearing the point that was made, that's like, this is like a hard thing for prosecutors to do, they don't have any experience in it. Right now, it's in criminal court, but using civil, it's a civil proceeding in criminal court. If you put it entirely to civil court, then it's like, it's also filing it like in a separate court and going to a separate,
What about
it's actually
the-
going to a different building.
What about our idea of one person being trained to do it?
Do you disagree with Judge Zoning?
No, I don't disagree. No, I just, I guess like, I just think his point is well taken, but it does kind of contradict a little bit of what Lisa's point was of like, it's actually now making it more of a different process than it is now.
You're talking two completely separate tracks.
And currently it's not quite that, because it's at least filed in criminal court. Yeah,
And it seems to me that, well, I kind of like that because then you have one judge that knows what's happening and one, and you're gonna have the judge in civil court going, well, what happened to the defendant? Do they have ability to pay before they make judgment?
yeah. Where is the criminal case at? Yeah, kind of thing, yeah.
Right.
If there is a criminal case as well, because there's no sign.
Well, can I tie it to the next thing that came up for me was on page 13? And I guess maybe, I think it does relate to this, of the burden. Like I think Lisa was saying, does it need to be clear and convincing? Could it be preponderance of the evidence? Would that have to change if it was in one court or the other or not?
No.
It could be either. We could
Yeah.
set it.
Yeah, the criminal judge applies the civil, the civil.
Follow the civil.
Okay.
Yeah, and in fact, they can do, you can do it both in the same hearing even. So they can apply the criminal burden and the civil burden.
I don't know. I feel like hearing Judge Zone said, but I don't know if we explicitly asked him, like, this is going to change a whole thing. Do you thought about that?
No, and I mean, maybe it does make more sense for it to go in the civil court.
On a DUI, they shift gears and do it.
But I think what was his biggest reason for taking it to civil?
It's not
Thinking-
criminal.
We could apply, for instance, service rules, the civil
Right.
service rules and basically
Summary
other
proceedings, right?
civil rules that can apply. I mean, we can use the rental escrow as kind of a model for how we do some of this, although I still think we should look into just direct payments to the providers instead of going through a registry, which I don't understand why we have to go through a registry.
Yeah.
That doesn't make sense to me, frankly.
Or
So,
they have the crime before.
Okay, well, and then I guess it goes to civil for this next round. We'll see what people say.
Victim services team.
Yeah, that's right, yeah.
Because I think you and I are kind of, yeah.
But he said it's not a great use of using the very tight criminal resources.
Right.
So it's less criminal.
So, I mean, my suggestion on all of that is to have you and Eric work with the judge to offline to try to, and maybe with.
Come up with the best answer.
And get rid of the registry. I just don't think.
Is that including the standard, the evidence standards?
So you want it to be preponderance of that?
I don't know. I thought that was a good question. I hadn't
So
considered.
this is one that we need to like, so that one, so there are decision points and the way Eric will do that is he'll put both those options in there, just so we know that that's a decision point. Just like we probably humanely go for decision points, but we're not really changing previous language. So I would have him, when you're talking to him, have preponderance of evidence as an option, but make this a decision point for us. Yeah.
Because if I'm clear,
Holy cow.
I think, yeah. This is not for the animal cruelty conviction. This is to get your animals taken away.
Yeah.
Would be lowering it to get your animals taken
So
away.
it's already lower, right? Than it's right now.
I just was clear.
No, I know, but so it would lower it
Even further,
either further.
because we are looking out for the safety of the animals.
Yeah. No, agreed. Yeah.
So also, is this somewhere in here, we look at that, the way that Texas is doing? I know the order for Minnesota, but I think Texas seems like a more apt.
So look at Texas.
Well, no, she gave those three options.
Yeah.
Oh,
Like the 10-day, like if you don't get back to us, we're letting them sell the dog,
Minnesota.
which seems.
More severe, right, rather
Severe.
than Texas just schedules.
And Texas says when they issue the warrant, it's scheduled for such and so date, the person's got to show up. It should be written that if the person doesn't show up, they relinquish their opportunity to have.
Sorry,
So that's
or
already,
money and.
that's already in here. Or there's a preliminary hearing.
Without good cause. How about that? Doesn't
Did you
show
say cost or cause?
good cause.
Okay.
If the defendant fails to respond to the notice for preliminary hearing, right?
Yes, yeah.
So,
But we were talking about how we can make it so there's not like this second service of process. That's kind of, it got a little confusing me. I want to see what that looks like.
okay, okay.
And
Okay. And, yeah,
We're tracking.
I just think that, I'm looking for the committee to kind of bless you working with the judge to try to straighten that out
Yeah.
rather than trying.
so just so I understand, try to clear that up, get a little simpler. There is some sort of like, default judgment that happens, but make it more clear.
Yeah,
how that happens.
and they're like, the hearing is set when the service is
Yeah.
accomplished.
Texas model is what you're.
Yeah, yeah.
I'd also love to know, like, is that as a junior member, how do we think about like burden of proof? And like, what is the discussion around, like, how do we determine what it should be? Like, in the criminal world, it's sort of decided for us, but is it severity of the crime? So like the more severe the
And,
crime, the higher the burden, or?
So it's easy it's somewhat easy and often on the preponderance with a lot of the civil stuff. And
Yeah.
then the beyond reasonable doubt. It's the clear and convincing. It's when do we put in the clear and convincing, which is the kind of more complicated one.
Yeah.
And so here we're taking away somebody's property, but I think what Lisa said, and I think that's right, is that other places you can lose your property under preponderance of evidence standard. But is this different that you're losing the pattern animal? That's why you would have a little heightened standard like clear and convincing.
Yeah.
I think we all just have to make that judgment.
Okay.
Should we be thinking about animals as property?
I mean, our director of, what's her name? Our director of animal welfare, for the Department of Public Safety, who's done this for years and taught it, says that they are property. That's their legal.
Oh, yes,
Yeah.
right.
People treat their kids like property too.
Yeah, I'm
Unfortunately, if it,
I'm
well,
making a philosophical quip.
No,
Yeah.
I-
so if
Notice.
I'm treating my cats more as property when I spend $1,000 for the medical care. So
You're
if I
required
see
to
your
under
philosophy-
Vermont law, it sounds like.
But
I don't think so.
She said, I asked her that question.
Oh, so that was what you were.
The medical care, right.
She said you're legally responsible for, like, do I have to get a kidney transplant?
No, you don't, no.
It was cheaper to put the cat down than it is for medical bills. I know which way I'm going.
Right, I think that's right, because she said you can dispose of your property, you can dispose of that
But-
animal as long as it's not a cruel way. is
But
what
she also said you're required to. I mean.
I do remember her saying something like that, but I don't think it was for, your pets.
Said that, I think that was like one of my.
there was like a medical standard of medical care. Are we on page 15? Does anyone know?
I think can we move off of 13?
Oh, yeah, I was trying
You're
to,
well.
I was just trying to just give you the rest of it.
I have
Unless there-
14.
I just want to make sure that I get everything done. So 14?
As the owner, you're responsible for food and medical care, it's obligated.
Hmm.
Because she was saying that money Yeah, anyway.
Boon for vets.
So I put this, in-
Right, I mean, yes, maybe
I'm
you're
gonna-
responsible for medical care, but the medical care could be euthanizing this animal.
That's, yeah.
I had two things on 14. One is a note, I don't know where it goes, but I feel like it's a decision to be made. And I feel like the director of animal welfare said she could provide language on it, is what are the standards that a agency has to meet in order to take possession of an animal? And then on line 14, I think Judge Zone mentioned, what are reasonable costs? Like, this more clarification needed. He said like, because he said like, you could say approve $100, but maybe there's only $50 worth of, but they could just
Oh, that
say,
was when he was talking about,
The register.
the like holding the money and how they can
oh, but
just
we're
like,
switching out of
get
that.
money. Yeah, yeah, yeah.
Yeah,
I think we should switch.
yeah.
But I do still think who determines reasonable cost? But I guess that's where that it's important to me that the entities that are requesting possession meet some level of care.
Right, I think, I mean.
People just
they would-
working the system.
This would be a practice where the entity providing the care goes and argues that this is how much it should cost, and they can have an argument, and the judge is ordering the alleged offender at that point to pay for it, right? I mean,
Yes, like in an RJO, restitution order, there's a 60-day timeline that the defendant can appeal a restitution order basically on an argument on unreasonableness. So, you crash into somebody else's car in a negligent operation, you might have to pay them back, but they like totally falsify how much it costs, then you can do that. I'd imagine that would be kind of the same process here.
Yeah.
But I think where Zone was having the issue was the prepayment.
Yes.
Yeah. So how you,
It was not so much the prepayment, I think, as the like disbursement to without, are they filing receipt?
yeah, because it was like an estimate of reasonable.
Oh, I'm sorry, you're saying prepayment to the
Yeah.
caregiver.
Yeah.
Not prepayment by the.
Yeah.
Okay,
Yeah,
gotcha.
because they're basically like, how much is this going to
Yeah.
cost for you to hold the dogs? Oh, it's gonna cost $100 a month. When is there an assessment? Was that a reasonable assessment? I think.
Yes.
Per diem for boarding.
Right, because we do not,
By animal species.
So, but it sounds like, I mean, the idea is that this hearing, they come in and the number one is your pet back. Want your pet back, you're gonna have to pay for its upkeep until we've gone through this process, right?
But
Either the
at
civil
what
forfeiture
rate?
or,
So it's, if you want your pet back.
I mean, isn't that the idea is giving the person a chance to say, yeah, I'm not gonna pay that, and that means that you've given up title essentially.
Okay.
That's the decision point that we're trying to force to be earlier in the process.
Is-
Pain, or you give up the title so they can
but again,
dispose of the animal.
Yeah.
Like-
Adoption or whatever.
So that you don't get in a position where they're not paying, they're not giving up, they're not forfeiting. The dog is, the animal is held in being cut.
If you don't pay over X number of days or whatever, I think the idea is that, well, then you've given up titles.
If you're poor and don't
I
have
mean,
money or.
it's what's
Yeah.
happening with people's cars getting towed. We should not set up a system that just leaves it.
Just poke in the hole.
Yeah.
Willy-nilly. Right, I agree with Karen.
All right, well, we have 10 minutes. Let's have the last thing. We'll have more discuss.
Are we doing, are we gonna, so this, can I ask, on page 15, the
This-
bottom cost of care action, is that all ostensibly gonna go away?
You submit.
If an animal is seized under the section, the state or custodial caregiver may commence civil proceeding?
No, I think we're trying to put
We're
that
gonna
into
come
the
up with a
civil,
new-
into the civil realm, number one, and hopefully like a direct payment instead of
Yeah.
registry, because
Okay,
it's.
I was intrigued by Lisa's point that you're giving evidence to, in an ongoing criminal investigation to a layperson by allowing the
Well, the
custodial
custodial
caregiver to commence the civil proceeding, but if that's not happening.
We are doing some good work
All
right now.
right, so I think, I mean, we do have a few more pages to go through, but why don't we go through those when we have the rest of the people. And we'll go back to that page 9 discussion.
I mean, should we go through all of it again?
I don't think we have to go through all of it. I mean, enough of us were here. I'm not delaying everything.
They can listen
With
online.
Eric.
People need to be in their seats. But on that other one, I think we do need to have a little further discussion.
Can I wait, Mr. Chair, can I wait to meet with legislative council responsible for this bill until after we've had the rest of the discussion?
Testimonies. Okay.
And committee discussion.
We have Steve Bro, he knows what he has, and we have what's our first name this time? So after the floor,
We have another.
We're done.
after the floor, we have,
the
State's
whole.
Attorney Gerhard from Lamoille County, going to come in and testify on this bill.
Floor and then caucus of the whole.
So 3:45 is what we're, that's the.
All right.